Before going into the topic details, I want to bring your attention to the UPSC coaching programs offered by ClearIAS. ClearIAS offers online and offline courses to help candidates get selected for prestigious government services like IAS, IPS, or IFS. ClearIAS Prelims Cum Mains (PCM) course provides a highly effective study plan, well-organized subject-wise videos, study materials, mock exams, and guidance to cover the entire GS syllabus of UPSC CSE prelims, mains, and interview systematically. As a limited-period offer, there is a 40% discount on our online courses. Enroll now.
The nature of judiciary as per the Constitution is it is independent as well as integrated judiciary. Independent judiciary means our judiciary should not be having any kind of influence of the executive. Okay, the judiciary should be having the freedom to act independently without having the influence of the executive. That is what do you mean by independent judiciary. Integrated judiciary means you have the Supreme Court of India, you have the High Court at the state level, and you have even the subordinate courts. Now, all these three levels, be it the Supreme Court of India, be it the High Court, be it the subordinate court, you have only a single fundamental law of the land, that is the Constitution of India. Does the state have separate constitution? No. It is only the single integrated judiciary. Fine? So, at the same time, we are independent and integrated. Now, who will appoint the judges of the Supreme Court? The judges of the Supreme Court shall be appointed by the President of India. The President of India. Now, it will be on the basis of the recommendation of the Collegium. Collegium. Collegium means it is the Chief Justice of India plus 4 senior most judges of the Supreme Court. So, in order to maintain the independence of the judiciary, the judges will be recommended by the Collegium, which consists of the Chief Justice of India and 4 senior most judges of the Supreme Court, and this is what do you mean by Collegium. So, they will recommend the name to the President of India. The President of India will have to appoint. Now, what about the tenure of the judges of the Supreme Court? The tenure of the judges of the Supreme Court. Tenure, the term. How many years? 5 years. Is it 5 years? The tenure is not provided in the Constitution. The Constitution says that it may be 65 years of age. Maximum age a person can serve as the judge of the Supreme Court may be 65 years. The person who gets appointed at the age of 58 will have 7 years. A person who is getting appointed at the age of 63 will have only 2 years. So that keeps on varying. Fine? So the maximum limit is 65 years. Who will decide the salary? The salary would be decided by the Parliament of India. Now, who will remove the judges of the Supreme Court? Who will remove the judges of the Supreme Court? See, the removal of the judges of the Supreme Court will be also done by the President of India, but it will be on the recommendation of the Parliament of India, not on the aid and advice of the Prime Minister and the Council of Ministers. It will be on the recommendation of the Parliament of India. So, the Parliament of India will have to pass a resolution with a special majority to pass it to the President of India that you will have to remove this particular judge. Now, what can be the reasons for the removal of the Supreme Court judge? The reasons are provided in the Constitution. Number 1 is proved misbehavior. Proved misbehavior and incapacity. Proved misbehavior and incapacity. So, 2 grounds are provided in the Constitution for the removal of the judges of the Supreme Court. Number one is proved misbehavior. Number two is incapacity. Who will remove the judges of the Supreme Court? It is the President of India. On whose recommendation? It is on the recommendation of the Parliament. Is it on the Prime Minister and the Council of Ministers recommending? No, it is on the basis of the recommendation of the Parliament. Why, sir, Parliament? To maintain the independence of judiciary, isn't it? If Prime Minister and the Council of Ministers are recommending the removal of the judges of the Supreme Court means, can we say that the judiciary is independent? No, Mr. Modi will call the President of India, sir, remove this particular judge. Isn't it? So can you say that that particular judiciary is independent? No. So that is the reason why our constitution says that it should be the Parliament of India. The Parliament will be consisting of the ruling as well as the opposition front to maintain that independence, neutrality. Got it? Fine. Now regarding the jurisdiction of the Supreme Court. Now what do you mean by jurisdiction? What do you mean by jurisdiction? See, jurisdiction means the extent of power. Okay? It is the extent of power. Extent of power. In other words, suppose if a crime has got occurred in Maharashtra, okay, murder. Now, this is Kerala High Court. Now, what we would say, the Kerala High Court does not have territorial jurisdiction over Maharashtra. Are you getting what is jurisdiction? Jurisdiction means the extent of power. The crime happens in Maharashtra. We say that the Kerala High Court does not have the territorial jurisdiction over Maharashtra. So there are different types of jurisdiction. Okay, different types of jurisdiction. Before that, you need to understand the original jurisdiction. What do you mean by the original jurisdiction? Okay, original jurisdiction. Original jurisdiction means the court of first instance. The court of first instance, which means what? Those types of cases that lands in the Supreme Court in the first instance. That will directly land in the Supreme Court, not in the subordinate court, not in the High Court. That may be landing directly in the Supreme Court. Such kind of cases comes under the original jurisdiction of the Supreme Court. Say, for example, when you speak about the pyramidal structure of the judiciary, you have the Supreme Court, you have the High Court, you have the subordinate court. Okay, subordinate court. Suppose criminal cases, the original jurisdiction lies with the subordinate court. If there is a murder, that case will be heard in the first instance by the subordinate court. Fine. So the original jurisdiction over the criminal matters lies with the subordinate court. Now, what about the civil matters, civil cases? Say, for example, the land disputes. The civil cases, the original jurisdiction lies with the High Court as well as the subordinate court. Okay, High Court as well as the subordinate court. Now, what cases the Supreme Court can hear in the first instance? The classic example is if there is a dispute between the center and the state. Okay, if there is a dispute between the center and the state. If there is a dispute between state and one state, those cases will be directly landing in the authority of the Supreme Court of India. It is not in the High Court, it is not in the subordinate court. Those kind of cases will be directly landing in the Supreme Court of India, and this is original jurisdiction of the Supreme Court. The original jurisdiction means it is the court of first instance, that is those cases landing directly in the Supreme Court, is what is the original jurisdiction of the Supreme Court of India. Now, what do you mean by the next type of jurisdiction is writ jurisdiction. Writ jurisdiction. Now, the question here is that, sir, you have told us that original jurisdiction means the court of first instance and the center state dispute will fall under the original jurisdiction of the Supreme Court. Now, can an individual cannot approach the Supreme Court in the first instance? Yes, he can when his fundamental rights are violated. Isn't it? You remember I have told you earlier, once the fundamental rights are violated, that person can directly approach the Supreme Court of India. Now, what can the Supreme Court do? The Supreme Court will issue writs. For what purpose? For the establishment or reinstatement of the lost fundamental right. This is what do you mean by the writ jurisdiction of the Supreme Court. Okay. So, the writ jurisdiction of the Supreme Court has one of the inevitable feature that one person's fundamental right needs to be violated, and it is only on that matter that the writ jurisdiction can be exercised by the Supreme Court of India. Okay, fine. So, that is what is writ jurisdiction. Now, you might have heard about the appellate jurisdiction also, isn't it? Appellate jurisdiction. Appellate jurisdiction means those cases by means of appeal the Supreme Court can hear. Okay, those type of cases by means of appeal the Supreme Court can hear. This is what coming under the appellate jurisdiction of the Supreme Court by means of appeal. Fine. There is one more jurisdiction for the Supreme Court, and that is advisory jurisdiction. Advisory jurisdiction of the Supreme Court. What do you mean by advisory jurisdiction? The Supreme Court has the capability or the authority to advise the President of India. The Supreme Court can advise the President of India when the President refers the matters to the Supreme Court. So, the President of India can refer some matters to the Supreme Court of India. Say, for example, if there are some doubts regarding pre-constitutional treaties. Say, for example, regarding the Mullaperiyar water treaty, one of the treaty which have got commenced pre-constitutional time. So, the President may have some doubt. The President may be not some legal luminary, so he will have some kind of doubt, isn't it? So, the President can refer this matter to the Supreme Court of India. The Supreme Court should compulsorily provide the advice to the President of India if the matter is a pre-constitutional treaty. It is compulsory for the President of India. Sorry, it is compulsory for the Supreme Court of India to provide the advice to the President of India. But if it is any other matter, say for example, now the government is enacting a law. The government is passing a law and it is sent to the President of India for the assent. Now the President has some confusion whether this law is violating some fundamental right or not. The President is not a legal expert. Now the President will send this matter again to the Supreme Court. Now, if the matter is legal, it is not a compulsory provision for the Supreme Court to provide the advice to the President of India. If it is a pre-constitutional matter, the President of India should be provided with the advice by the Supreme Court. That is compulsory. Okay. If it is a pre-constitutional matter, advice is compulsory. Compulsory. If it is a legal matter, the Supreme Court may or may not provide the advice. Then, just imagine the condition that suppose if the President has referred the matter to the Supreme Court and the Supreme Court has provided the advice. Is it compulsory for the President of India to act according to the advice of the Supreme Court? No, that is the most important thing. It is not binding on the President of India to act according to the advice of the Supreme Court. He may have asked the Supreme Court for the advice, but once the Supreme Court gives the advice, the President says, okay, fine, leave it. Rest depends on me. I will decide. That's it. Got it? So what kind of jurisdiction is this? It is advisory jurisdiction. Clear? Now, when it comes to the seat of the Supreme Court, the seat of the Supreme Court is New Delhi. And of course, you do not have any doubt, the seat of the Supreme Court is New Delhi, isn't it? Now, when you talk about the Supreme Court's present strength, understand that now the Supreme Court has 34 judges. Okay, 34 judges. That is 33 judges plus 1 Chief Justice of India. So, in total, the Supreme Court has 34 judges now. Now, what do you mean by judicial review? Judicial review. It is the way of checking and balancing, or you may say that it is the way of reviewing the actions of legislature and the executive by the judiciary. Okay? Say, for example, Article number 12 of the Indian Constitution provides you for the definition of state. It says that the Parliament of India, the state legislature, the union executive, the state executive, the local self bodies, all these things comes under the definition of state. Article number 13 says, any law that is inconsistent with fundamental right shall be null and void. So, any law that is in violation of the fundamental right shall not exist. That will be null and void. So, what can you check here? Law means it is a general word here. So, it is very clear that law means it is the action of the Parliament of India. It is the action of the state legislature. It is the action of the union executive. It is the action of the state executive. So, all these kind of documents can be checked by the judiciary. And if the judiciary feels that it is violating the fundamental right, it can strike it down. This is what do you mean by judicial review. Okay. Checking the actions of the executive as well as the legislature. Be it the parliamentary laws, the state legislative laws, be it the ordinances, be it the rules, regulations, all those kind of things may be checked by the judiciary. That is both the Supreme Court as well as the High Court. Okay. The Supreme Court as well as the High Court. And if they feel this is in violation of the fundamental rights, they can strike it down. And this is what do you mean by judicial review. And this is one of the basic structure of the Indian Constitution. It cannot be taken away. Okay, it cannot be taken away. Nobody can say that this particular thing cannot be checked by the judiciary. Everything in India, practically 100% of the things in India will be checked by the judiciary. It is such a strongest judiciary that Dr. Ambedkar has put forward for Indian Constitution. Now, what do you mean by PIL? Or I say public interest litigation or social action litigation. Public interest litigation or social action litigation. So I have told you, I think I have told you even before that what exactly is public interest litigation and social action litigation. See, public interest litigation means, suppose there were some kind of rules and regulations followed by our judiciary that suppose if your fundamental rights are violated, okay, yourself has to approach the judiciary. It should not be a proxy approach. You should themselves or you should yourselves be approaching the judiciary. That is what do you mean by, that is what was expecting from the judiciary. But certain judges, say for example, the judges like Justice P.N. Bhagwati, Justice V.R. Krishnaiyer, Justice Chinnappa, they have extended the scope of the considerations of judiciary in such a way that they said, sir, it is the justice that is getting matter. A person who is living in slum, working day and night to meet daily expenses, at least 3 times meal, would not be able to travel long way to Delhi and speak about their pathetic condition. For them, if there are some good Samaritans, some public welfare oriented people, if they come to the judiciary, we will definitely hear their petition. This is what do you mean by public interest litigation. It is for the public interest, not for the personal interest, not for the private interest. It is for the social action or the public interest. Such kind of petitions are known as public interest litigation. Say, for example, a person is residing in Kerala. This person approaches the Supreme Court of India for those people living in the banks of River Ganga. Fine? Due to the river pollution, this people suffers this people is violated with the right to life and personal liberty. But these people, they are very poor. They are not supposed to approach the Supreme Court of India. No problem. A person who is public welfare oriented from Kerala approaches the Supreme Court of India, file a public interest litigation for those people living in the banks of, on the banks of River Ganga. The Supreme Court will have to now take into consideration this particular proposal or this particular petition, and they are not supposed to reject it because of the reason that it is not filed by the aggrieved person. Why? Because the justice is denied here. Justice is what is going to be important. That should be considered by the judiciary. Fine? So this is what is public interest litigation. So you may say that this is a kind of judicial activism. Okay. You may say that this is a kind of judicial activism. See, whatever, there are some judges, they often feel that whatever is our duty, we will perform that, we will go back. There are certain other judges, they will feel that it is not about our duty, it is justice that needs to be prevailed. So for that, we will sometimes step over and deliver the actions that will ultimately lead to the delivery of justice. Fine? So this is what is the concept of the public interest litigation. Okay? The public interest litigation otherwise is also known as social action litigation. Okay? Social action litigation.